Good evening, learners. Today we are going to discuss company law, and I've prepared some questions here. There's a question here which has been tested for many sittings. It is question under company meetings. The case of Sharpe versus dawes. This question has been tested in 3 sittings. The first sitting, May 2017, May 2015. The candidates were told to discuss 4 exceptions to the rule in Sharpe versus dawes (1875). In May 2017, candidates were told to explain the exceptions to the rule. And the question read like this: in Sharpe versus dawes, the word meeting means coming together of more than one person. With reference to public companies, summarize 5 exceptions to the rule in Sharpe versus dawes. It was also tested. In the case of Sharpe versus dawes, indicate that one person cannot constitute a meeting. Explain 4 exemptions to this rule. So I've researched today, so I want to share the content with the learners. So this question is under company law, company meetings. We are going to start with quorum. Students should be able to explain what is a quorum. A quorum refers to a maximum number of persons or members who are needed to be present for a meeting to proceed to transact a business. And this quorum was explained in the case of dawes versus Sharpe versus dawes (1876). And in this case, a company convened a meeting with the business to be transacted was to make a call. Only one member attended together with the secretary, and the secretary was not a member. The meeting went ahead and a resolution was made to make a call. In the meantime, a member who did not attend the meeting was requested to make a call, but he refused and challenged the validity of the meeting and of the call in the court. And the court held that the meeting was not validly convened and therefore the call was invalid. The court explained that the word meeting prima facie means on the face of it means coming together of more than one person. Therefore, one person cannot hold a meeting. This decision held is called the rule in Sharpe versus dawes. Exceptions of the rule. Under the Companies Act of 2015, one person can form and register a company. In such a case, the person will be holding valid general meetings alone. Point 2. If the general meeting is convened under the directions of the registrar who has ordered that the members present will form a quorum. Point 3. If the meeting was ordered to be held by the court and the court has instructed that the members present shall form a quorum. Point 4. If the meeting is postponed and the articles provide that whoever attends shall be the quorum. Point 5. In case of a private company that has only one director, such a director will be holding board meetings alone. Point 6. If in the case of liquidation, only one creditor has proved its debts with the liquidator, then when creditors' meetings are called, the creditor will be attending the meetings alone. Still under company meetings, we can discuss something called prox. Students should be able to define who is a prox. A prox is a person who is appointed by a member to attend general meetings on his behalf if the member will not be attending. We have types of proxies. We have general prox or special prox. A general prox is a prox appointed by the member to attend and vote in the meeting in a way that he feels fit, while special proxy is a proxy who is under instructions on how to vote in a certain resolutions to vote if certain resolutions comes up. Then we proceed to the rights of a proxy. Point 1. To attend general meeting on behalf of the member. Point 2. To vote on behalf of the member. Point 3. To join other members and proxies to demand voting by poll. Point 4. To participate in discussions during the meeting, especially in private companies. Then we have revocation of proxies authority. The authority of a proxy can be revoked under the following circumstances. Point 1. If the proxy appointment form is not delivered to the company within 48 hours before the commencement of the meeting. Point 2. If the member attends the general meeting personally. Point 3. If the member directly revokes the appointment. Point 4. If the member dies before the date of the meeting. And finally, if the member becomes insane before the date of a meeting. Then we proceed to another question which is highly examined by the examiners, which is under the topic of directors, and it is called the doctrine of indoor meeting, the doctrine of indoor management, into bracket the rule in taquarn case. And we are going to see this doctrine is to the effect that a third party who is dealing with a company is not obligated to inquire whether the company's internal procedure have been followed or not. The law only requires such a person to have a constructive notice about the content of the company's public documents. Then we move to Royal British Bank versus Taquarn into brackets 1856. And in this case, Taquarn was a liquidator of a company that had taken a loan of £2,000 from the Royal British Bank by issuing of a bond to that bank. However, the amount had not been paid when the company went into liquidation. According to the company's articles, the director had the power to borrow that was authorized by an ordinary resolution. In this particular case, however, no such a resolution had been passed, even though the bond was issued under the common seal of the company and signed by the directors and the company secretary. Taquarn had refused to pay, arguing that the loan was not properly authorized due to the lack of resolution. The court held that the company was liable to pay. The court explained that a person dealing with a company is only required to have a constructive notice, but is not obligated to inquire whether the internal procedures of the company has been followed or not. Then we move to the exceptions to this rule in Taquarn case. The rule will not apply under the following circumstances: where the person suing is in fact an insider, example, the director. Point 2. If the person actually knew about the irregularity but did not do anything about it. Point 3. If the article has recommended special resolutions which has not been passed. Point 4. If there was some special circumstances which would have been made the outsiders to make an inquiry. Point 5. If the transaction is ultra vires as far as the company is concerned. Point 6. If the transaction relates to issues of a forged document without the authority of the board, example, a share certificate. So learners, that question is highly tested, and there is a possibility of the examiners to ask that question in this sitting. So I wish you the best as you prepare for your examinations, which will be administered in August. Have a nice evening.